For the most part, our estate planning is broken up into 2 levels. And these 2 levels will really encapsulate what most of our clients really need for an estate plan. Now, of course, there are clients that we have level 3 and 4, but for most of our clients, their estate plan is going to either be broken up into a level 1 estate plan or a level 2 estate plan. Let me explain the difference to you. A level 1 estate plan is a will-based estate plan that's made up of a will. That will contains a pour-over trust, a durable power of attorney, a healthcare proxy, an advanced medical directive, a HIPAA-compliant release, personal property memorandum, and a funeral services memorandum. We all know what a will is. That's a document that you create that creates a set of instructions that a court will have to probate or decide if it's going to be followed, in which you name a person or the personal representative to be the person who administers your estate in accordance with your instructions. Namely, it disseminates your assets to the heirs that you say, under the circumstances that you say. A healthcare proxy is a document that cloaks another person, namely the attorney-in-fact, with the responsibility to make medical decisions if you're unable to do so. A HIPAA-compliant release is something that's really important and works with your healthcare proxy. A HIPAA-compliant release cloaks your healthcare agent with the ability to review your medical records. How can a person make a sound medical decision if they can't go to the hospital or medical provider and get a copy of your medical records? How can they get a second opinion? The idea is we want to avoid petitioning the court for the ability to obtain those medical records, so every single one of our estate plans contains a HIPAA-compliant release. An advanced medical directive is a document that we create that says under what circumstances you would like to stop life-sustaining treatment. A personal services memorandum is a document that explains at your memorial service what it is that you would like. A personal property memorandum lists all of your assets and allows you the opportunity to say who gets what. All of those documents together are what we call a level 1 estate plan. And for 40 or 50% of our clients, that's just fine. For a smaller estate, for an estate that might be under $1 million, you could use a level 1 estate plan. For a single person's estate plan, you can use a level 1 estate plan. On the other hand, there's a level 2 estate plan. A level 2 estate plan is a trust-based plan that's designed to avoid probate, that a properly drafted trust with the assets aligned will in fact avoid probate. A level 2 estate plan contains everything that a level 1 estate plan contains: the will, the healthcare proxy, the HIPAA-compliant release, the advanced medical directive, the personal property memorandum, as well as the funeral services memorandum, and adds to it either one or a series of trusts that are designed to hold your assets and to ensure that any of those assets that are within the trust do not pass through probate. What we typically do is an individual trust for each person that works together. If the people are married, we would allow both people to be the trustees and the lifetime beneficiaries. That individual trust will hold all of the assets. My law firm does something just a little bit different if the circumstances are right for the right people. We oftentimes will create a realty trust, and we'll use a realty trust to hold a person's home or real estate assets. Now, many estate planners will say it's unnecessary or that the revocable living trust can hold the assets, and that's true. And oftentimes, many of those estate planners will advocate that you don't even need to record or file that trust with the Registry of Deeds, and they'll do what we call a Section 35 trust certificate. What a Section 35 trust certificate is a summary of the trust in which it names or gives a summary of the trust or names who the trustees are and who the beneficiaries are and grants those words of power, the ability to administer the trust. And in most instances, that's just fine and you don't need a realty trust. However, in some instances, and I've had this in my own practice, a title insurance company will come out and say, we need to find out who a successor trustee is. And that wasn't named in the trust. I had a case where my firm was handling a real estate matter and there was a recorded trust and the original trustee passed away and there was no successor trustee named in the trust certificate. And the title insurance underwriter that I was working with said to me, John, you need to record the trust. Well, no one wants to have a trust that's this thick that names every single person who gets something, what they get, what their name is, what their address is, who their kids are, and all of this personal information and file it as a public document that anyone can see. And that's the reason why we create a realty trust. We create a realty trust to ensure privacy, to ensure that anyone who's going to mass land records doesn't have the ability to see who it is the true owner or beneficiary of this home, where they live, and what they're going to inherit. So a level 2 estate plan, which is a trust-based plan, consists of everything that was in a level 1 estate plan, as well as oftentimes a realty trust. And then we would align your assets by properly recording them as a real estate attorney would do. And we would ensure that those assets are aligned and working and designed to accomplish the goal that you have. I'd encourage you to call us and set up a time for a meeting, and we can talk about whether or not a level 1 estate plan or a level 2 estate plan is right for you. Call us today.